Good morning. Please be seated. The next case is in re the dependency of CGS. And does counsel for the appellant wish to reserve time?
Yes, please. 3 minutes for rebuttal.
All right. Please come up and proceed.
Good morning. Moses Okeyo for the Washington Appellate Project, appearing on behalf of Mother in this case. Mother asks the court to reverse both orders terminating her parental rights for at least 2 reasons. First, Mother insisted on a physical face-to-face confrontation of each witness. That reasonable request was denied without a case-specific finding of necessity as to each witness. Second, I was shocked to learn in Washington a social worker can draft, sign, and file petitions to terminate parental rights on behalf of the department. A social worker signed both petitions to terminate on behalf of the department. She had no statutory authority to do so, and that constitutional violation invalidated the petitions and the termination order. A physical face-to-face confrontation at trial. A mother has a right to expect that before the government terminates her fundamental liberty interest in the care and custody of her children for the rest of her natural life and for the rest of her children's natural life, that she can insist that the government must bring each witness into her presence and prove its case before her. This right derives from the due process protections guaranteed by Article 1, Section 3 of the Washington Constitution. So our Supreme Court told courts to apply the Matthews test to the question of whether a person should be granted the procedural due process right to confront. So here in June 2021, 70% of King County was vaccinated, and trials could be conducted safely with social distancing and a few precautions. The department requested trial to be held remotely for its own convenience. Mother insisted on a physical face-to-face confrontation of each witness. Mother even suggested a few social distancing and clear face shields for each witness, some reasonable precautions. The onus was on the department to give a legitimate public policy reason why each witness needed to testify remotely. The court said, I'll read you what the court said, "I'm not going to order anyone to come to the courthouse if they're not comfortable. I don't need to hear a medical reason. I don't need to hear any other kind of justification other than I'm not comfortable coming to the courthouse." RP 22. The judge said in RP 24 and 25, he was not going to compel physicians and expert witnesses to testify in person because physicians are hard to get into court even during pre-COVID times. So under the first Matthew factor, the court said this parent had a fundamental liberty interest in the care and custody of her children, and that's where the analysis stopped. It ruled all witnesses could testify remotely, RP 25 and 26. Under the second Matthews factor, the court didn't analyze whether face-to-face confrontation is a reasonable error-reducing procedure, whether face-to-face was better than remote testimony. It made the conclusory finding there is no unreasonable risk of erroneous deprivation of rights. It assumed remote testimony was constitutionally equivalent to face-to-face testimony. It assumed face-to-face did not have any additional probable value compared to remote testimony. And under the third Matthews test, it did not analyze whether the government had a legitimate interest that could override Mother's interest in physical face-to-face confrontation. So remote testimony and face-to-face are different. They're not constitutionally equivalent. There is an intangible, real, and unpredictable effect of looking someone in the eye. It's always more difficult to tell a lie about a person to her face behind her back. So the right to face-to-face confrontation serves and ensures integrity of the fact-finding process. That's what Coy v. Iowa says. It also says face-to-face presence may confound and undo the false accuser. So just yesterday, this court said in a published opinion in the detention of LS that the right to confrontation assures accuracy of the fact-finding process, and it cited State v. Lee. So the accuracy compared to face-to-face is better compared to just watching some pixels on a screen.
Do we apply the same standard in this case that we would in a criminal case?
This is not, Your Honor, it's not the same standard. The Supreme Court said to apply the Matthews test, and that's what we are applying. And the two prongs of Matthews test, the second and third prong, similar to a finding under Maryland v. Craig of specific compelling need.
Doesn't the existence of the Matthews test suggest that there are cases where the trial court could appropriately conclude that remote testimony is acceptable?
Sure. But in this case, we're talking about this case where a parent insists on the right to face confrontation. Our Supreme Court has said to apply the Matthews test, and you have to find a compelling government, a public policy interest of the government that overrides the mother's interest in face-to-face confrontation. Our Supreme Court acknowledged in the welfare of MB that a fact finder who observes a witness in person is better able to judge their credibility. So we were asking for that right to confront, which we said was better than pixels on a screen, was better than having all the witnesses appear remotely.
Could it have been worse, though, if they're socially distanced and wearing a mask, like you suggested earlier? Well,
we didn't require them to be wearing a mask. They could have worn a face shield that we can still see their faces, and they could be socially distanced in court.
All right, got it. Thank you very much.
May it please the court, my name is Kelly Taylor. I'm an Assistant Attorney General on behalf of the Department of Children, Youth, and Families. This court should affirm the termination order as to CGS and WWS because the trial court here appropriately engaged in Matthews balancing and correctly concluded that the trial could take place with the witnesses testifying remotely. When the appellate court reviews Matthews balancing, there is the de novo review for the bottom line constitutional issue, but there should also be deference to the factual findings that were made by the trial court. And in this case, the factual finding made by the trial court was that we are in the midst of the COVID-19 pandemic. And there was no other factual information to counter that statement made by the trial court. There was nothing supplied by the mother's attorney to argue otherwise, which they now do on appeal. So the balancing that took place in terms of deference to the findings of fact in the balancing, they show that the balancing was done properly. The trial court also relied on the emergency orders which authorized remote proceedings, and there was nothing to counter the trial court's recitation of the content of the emergency orders either. So there's no case here that's been cited by opposing counsel to justify this sort of backward-looking rebalancing approach based on factual information supplied for the first time on appeal, and that wasn't before the trial court. The mother's claim of a constitutional violation really seems to be based on the right to confront witnesses under the Sixth Amendment in the federal context and under the Washington State Constitution under Article 1, Section 2, Amendment 10. But there's case law directly on point that states that that neither the federal nor the state confrontation clause applies to cases of deprivation proceedings.
Let's touch on why that they don't need the Fourth Amendment part of this in these cases. Let me tell you why they don't, okay? Since this woman doesn't know what she's talking about. The reason why they don't is because of this. There is no parent. The child was abandoned. That's why the Fourth Amendment isn't important, because they're not supposed to be taking children from actual parents. They're supposed to be taking children into custody that don't have parents. That's why the Fourth Amendment is not important, because you shouldn't be violating their Fourth Amendment rights. Why? Because you're not supposed to be taking kids from actual parents. That's why. Parents aren't supposed to be there to contest this type of thing. They're not supposed to be there because why? Because you're using laws for wards of the state, also known as dependent juveniles. That's why.
And those are the Welfare of SE, the Lucier case, and the Penelope B case. So here, consistent with the Washington State Supreme Court's October 2020 order and the King County December 2020 emergency order, the mother was present in person in the courtroom. She was there with her attorney. There had already been a prior stipulation allowing the testimony from the child, WWS, to take place remotely. And there was nothing after that first day of trial where there's this insistence that all witnesses testify in person that showed that there was some risk of an erroneous decision. There was no statement in the following 6 days of trial anywhere that there was some sort of technical glitch or some sort of inability to see or some failure to hear or an inability to consult with a lawyer.
Does it depend on who the witness is? I mean, are there different considerations, say, for a physician? I mean, physicians are hard to get versus a lay witness who may be more directly adverse to the litigant.
I think it's each case is different and is driven by the unique facts of that case. So I think there was this offer here in this case by the trial court to go through the witness list one by one and to just, establish a record and to weigh whether that witness should be allowed to testify remote or be required to come in person. And the response from the mother's attorney was, no, there is no need for individualized analysis. That was the position that was taken at the trial court level, that there wasn't any need for some sort of individualized analysis as to each witness. And there, as I stated previously, the child, at least WWS's testimony, there had been the prior agreement to allow his testimony to be remote. So I don't think I can answer that differently other than to say it really just depends on the witness and the facts of the individualized case.
Are you familiar with detention of, I guess it's LS that was referenced in counsel's argument?
I am not, no.
That's fine.
But in moving to the CR11 signature issue, the department's position is that this issue should not be reached because it is not manifest constitutional error if it is error, and we're not conceding it was, but they haven't met their burden to show that this would be manifest constitutional error. It wasn't raised below. So the effort to justify this being heard for the first time on review is really, they're trying to shoehorn this sort of CR11 issue into a constitutional issue by raising a separation of powers argument. But the problem with that is that it's really based on a false premise. There was no social worker drafting a petition here. This was the Attorney General's office drafting the petition.
Oh, but that wasn't known at the time the petition got filed with only the social worker's non-attorney signature, right?
The petition was filed with only the social worker non-attorney signature, that's correct. But the issue wasn't raised below. And so our office filed a motion to supplement the record to counteract the incorrect information being argued in the appellant's brief that this was a social worker
So
who
what
had
does
written.
what does Rule 11, which deals with signatures on pleadings, what does Rule 11 require before a trial court entertains a request for relief?
It requires the attorney's signature, Your Honor.
What does it require if that does not appear?
It requires that it be brought to the attention of the party responsible for signing it.
And is there any evidence in this record that that happened?
No, Your Honor.
This guy's joking, right? That's all they ever do is never sign, okay? They don't ever use attorneys, ever. I have so many orders of removals of my children. Now you want to say something? Do you know how many times I've sued for this? Oh my goodness. Like, they only care about certain people, I swear. I've got, like, removal orders galore. No attorney ever signs. Because they're scared because they know they don't have the laws they need to remove anyone's kids. That's why. They know how to read the law. That's why they don't sign. Because they don't want to get in trouble for breaking the law. That's why.
And so if that did not happen, then there would not be facts in the record from which we could say the trial court should have ruled sua sponte, correct?
Correct.
And if those facts aren't present in the record, then any error, constitutional or otherwise, is not manifest in the record.
Yes, I agree with that analysis. It is a manifest constitutional error, and it shouldn't be reached. If this court does decide to reach the issue, any potential flaw in it would have been harmless error, because as was the case in the MT, when it was brought to the attention of the deputy prosecuting attorney, within 24 hours, it was signed and refiled. And that's what would have happened here. It would have been immediately signed and refiled. So it is.
Is there any issue with a statutory authority extending the ability to a social worker on behalf of the department to sign a petition in court? I mean, does that implicate the Supreme Court's regulation of the practice of law?
Well, that was addressed in the MT case, and in MT it was in the court held that the social worker did not engage in the unlawful practice of law by signing and filing the petition, and that the Washington State Supreme Court did not preempt the authority in law to file the petition. So if one follows the logic in MT, then there wouldn't have been any preemption by the Washington State Supreme Court.
Is there a reason for that? Because certainly, usually we think of signing petitions and filing them with the court clerk as falling within the practice of law. Why do we say that's acceptable?
Well, in MT, it was based both on the court rule and the statute. And in the termination context, RCW 13-34180-1 refers back to RCW 13-34040, and that was the statute addressed in MT. So the same logic should apply. But again, if this court does reach this issue, it would have to be manifest constitutional error, which it's not. And then if it is error, then it would be harmless, because it really wasn't an error that would have affected any substantial right. So the claim defect should be disregarded in that it didn't affect the outcome. I am almost out of time. I just want to close by mentioning that this termination of parental rights trial took place over a year ago, and these two children have now been in out of home care for 4 years. They are painfully aware they have not been adopted yet, and the department asked this court to affirm the termination order to allow the children to move forward with adoption. Thank you.
Thank you, counsel.
Briefly talk about the
So the new case you cited to us, LS, detention of LS, was that a mental illness case?
it's a mental illness case.
And is that the case, I don't remember case names, then when they're new necessarily, but is that the case where two judges joined in the majority and Judge Warswick dissented? Was that a 2-to-1 opinion? It came out yesterday or the day before? Is that the one you're talking about?
I didn't read it that closely. mostly cited
Well, it's
for
not comforting since you want us to apply it to your case. But my question is, let's assume it's that case because it came out within the last couple of days. In that case, the operative facts were that the primary witness for the government had never interviewed the person who was detained and sought to be detained longer, but instead relied on data and opinions of other people who had interacted with LS. But those people never testified at all. It's not that they testified remotely or on video or otherwise. They didn't appear at all. And the only person who appeared for the government was the person who was testifying as to what other people said. Isn't that case better explained by that phenomenon than by the idea that the person who testified as to what other people thought was doing it remotely rather than in person?
I said that case for a proper analysis of the Matthews factor. And there you see that the second and third parts of Matthews are properly analyzed. In our case, they're not. So it was mostly for that assertion that in order to do a proper Matthews test, you have to analyze all three factors. And in our case, they didn't.
Yeah, but wasn't part of the dispute in that case, and I'm going off the top of my head because I read it and moved on because I didn't know we'd be talking about it today. But part of the dispute there is whether there's a likelihood of a misadventure in the fact finding based on the fact that these people aren't testifying at all, not the mode by which they're testifying.
So we are saying the question is whether you have to analyze both remote and face-to-face and see if one of them is better for fact-finding. And the court didn't do that. So in this case, there were 14 witnesses.
But that's not really the test, is it? I mean, it's not that we ask is one better or not. Don't we have to ask on a case-by-case basis in an individual case, is one method likely to undermine the integrity of the fact-finding in this case?
Yeah. So when somebody so the probable value of confrontation was supposed to be analyzed, which wasn't analyzed. So when you're asking for confrontation, and then somebody says, but remote is just fine, but you haven't analyzed whether constitutionally whether confrontation would provide a more accurate fact-finding process.
Got it. All right. We understand your argument. Thank you very much. The matter is submitted. We'll be at recess.
All rise. Court is in recess.